you'll see the slides. Some of them are just kind of a wall text. You know, it's not my intention to read all of them to you, but some of them, particularly when we get to looking at later on in the presentation, there's a few that I will read to you guys verbatim, and then we can talk about it. Also, this is your training session. We don't have a whole bunch of people here, so if you want to just, if you have a question, just ask it. I mean, I think I have a slide at the end that says, now or any questions, but admittedly, there's quite a few slides here. If I ask you to hold it to the end, you may not remember, so just feel free. Yeah, the primary thing I think about and want to impart to you guys about what you guys are doing here as a planning commission is it's frequently about balancing, right? You're balancing the many interests and perspectives of the public. We talk about the public. The public is not just one thing, and it's not just one idea or one attitude. So as you deal with people's land use and zoning issues, the individual applications, and you deal with the larger, broader policy documents, the planning part of this, you're balancing all those competing interests and perspectives. You're balancing the interests of the public. When we talk about that sort of public as a group, you sort of think of it when applications are before you. So there's the applicant and there's the public. And so often what you're doing is you're balancing between those two, and the outcomes of your decision should be fair and sustainable. Now, what does that word mean? In planning, sustainable has a kind of a specific meaning, and but basically what it means is that you're balancing the interests and the desires of the present residents of your city versus the future residents of your city. And so it can be very often, we kind of maximize, short-term gain at the expense of the future residents of a community. Review and decision-making. You guys are going to be looking at a whole range of applications, rezoning, special uses, conditional uses, site plans. All of them have different types of level of review, different standards. But the overarching thing is that your decisions have to align with the city's comprehensive plan, the city's land development code, and then there are other planning documents. As you may be aware, there's a master plan being created for the CRA. So those are, that's another thing that the decisions have to be made. And then of course there's just the broader, the city's goals and objectives. So that's always overarching all your decisions as a planning commission. One of the important roles that you do is policy development. It's something that you often share with the city commission. The city commission is the governing body of the city of Crescent City, and ultimately, they're the deciders of the ultimate direction. But you guys, and we'll talk about this a little bit more, you guys, advise them. And one of your important roles is to develop a policy, and that's kind of done in two ways. There's the formal documents. There's the comprehensive plan, which is a very broad physical development plan for the city. So policy is created through that. Policy is created through, again, things like the CRA's master plan, and I know Charles often brings things forward both to you guys and to the city commission that are essentially policy decision makings. And again, any decision associated with this, has to be, fair, defensible, and in line with the city's, community's values and objectives. So you guys are instrumental in that, and your role involves not just decision making, but also you're helping to create the vision for the city. And a lot of communities, that vision first comes from the Planning Commission in policy documents, and then is adopted by the City Commission. So you guys have an important role in terms of establishing what the vision for the city. Public engagement. Public engagement is another important role of the Planning Commission. The City Commission deals with a whole range of issues, the budget. Many of your items go first to the planning board and on to the commission. You guys take a deep dive on planning and zoning issues, which is often just a very small part of the city commission's agenda. So given that role, given that perspective, a lot of what happens at planning commission meetings is that's where a lot of public engagement occurs. It's often the first point of contact on an issue, right? Applications come here and then move on to the city commission. And, very often it's at the planning commission where it's discovered that things are, that there's a lot of interest, in that particular subject by the community. And, if something's controversial, you guys are going to hear about it first. And a lot of times planning commissions will take more time, with public input than is possible at a city commission meeting. Now, very often on controversial items, city commissions can't really escape having to spend a lot of time listening to a lot of people come forward when something's controversial. But it's very common in many communities where the planning commission hears from the public at much greater length than the city commission is able to do on their agendas. And we already mentioned this, you guys play an important advisor role. So there are some items where you guys are decision makers, and there are some items where you're an advisor. So for example, a site plan gets submitted, it gets reviewed by the Development Review Committee. It goes through kind of a wash and rinse cycle with DRC. We initial submittal, we give them comments, they make revisions, and all that's done before it gets to you guys, and then you guys are the final decision makers on site plans. But on something that involves an ordinance change, so comp plan amendments and rezonings involve ordinance changes. The city commission has to adopt an ordinance to change the future land use on a piece of property, rezoning, so that you have an advisory role. And so even though you're not making the ultimate decision, you still have a crucial role of, I already talked about public engagement, but just basically making sure that a thorough analysis has occurred along with that public input. You also have a responsibility to educate yourself about planning matters. This is a very broad topic. You need to educate yourself about the city's land development code. Now, you guys have, a lot of times, land development codes have been around for a lot of years, and The only way you get exposed to it is if you sit down and read it, or you have a case in front of you, and so you'll be familiar with pieces and parts of it. You guys have a little bit of a head start since there's an update going. You've heard a lot about the land development code, but there's learning about the town's comprehensive plan, master plans, and then there's just learning about planning in general and what's going on in the planning community. So, I wrote this slide. Now, I had somebody in my office who's less than 30 read this, and he asked me about you talk about attending training sessions, workshops, and conferences. He said, I don't like to talk to people on the phone. He's closer to 25 than he is 30. Actually, I don't even like to talk to people on phones. I don't like to go to conferences. You didn't mention the internet. And he's absolutely right. There are a lot of sources out on the internet, and some of them are free. There's sites called Planetison, Cyberbia, kind of a forum. The American Planning Association has a lot of stuff on the web. There's also memberships there's discounted memberships for planning commissioners, and there's also potential group memberships that the city could purchase. Now, don't just rush out and ask Charles. This is probably something that has to be budgeted for. If you guys are interested, I could at least sort of find out what that costs, and so that that's something that could be worked into the budget. Important responsibility is ethical standards. I mean, I'm saying it. I think this doesn't need to be said to most people. They understand that, but obviously, it's very important that when you approach all these matters, that your private interest, and we'll talk about this, don't creep into your decision making. Your decisions, have to be made in the interests, fairness of the applicant, interests of the public, and the city. Legal compliance. Almost everything you do as a planning commissioner has some sort of legal constraint associated with it. So there's a famous court case relating to a legislative taking of somebody's property, and the Supreme Court said, the police officer has to understand what, the people that they're dealing with, what their constitutional rights. Planners and planning commissions have to do that as well. So, so that's something that you just always have to be cognizant of when you're making a decision. You're dealing with people's property rights, and there are protections in the U.S. Constitution, and we're in the state of Florida. As you may be aware, Florida's legislature and governor are conservative Republicans, and so they have built in even more constraints in terms of what cities can do, and they provide an even greater protection for private property rights in the sense that, for example, we'll talk a little bit later about rezonings. Rezonings in many states are legislative acts, and we'll talk about what that means and how that legislative decision. But in Florida, they're quasi-judicial. And so there's a higher level of standard in terms of decision making, and that is something that has come out of, that comes out of state law. There are things like the Burke-Harris Act. So the Burke-Harris Act is basically has expanded the takings law that would apply in general in the United States. So you have to be very careful any action that you take that would diminish the value of somebody's property. The constitutional standard typically is if you leave them some reasonable use of the property, it's not considered a taking of somebody's property rights. But in Florida, you have to be very careful about any decrease in value of somebody's property. And recently, within the last 3 years, they've required every local government to adopt a property rights element in their comprehensive plan. They basically specified what that had to say. And so every jurisdiction has that in their comprehensive plan now. Comprehensive plan consistency. All land use and zoning decisions have to be consistent with the city's comprehensive plan. The comprehensive plan covers a lot of subjects. It is much more general than a land development code. Land development code has very specific standards. Land development codes have some general standards, but they also have very specific standards. Things like setback, like how close can an accessory structure can't be closer than 5 feet to a property line. You wouldn't see that in the comprehensive plan. So it is more general. So sometimes it can be harder to interpret, but every decision does have to be consistent with the comprehensive plan. And so one of the things that, one of the primary things you're looking at in consistency is there's a future land use map in the comprehensive plan, and all zoning has to match that future land use map. So when I'm looking forward for changes of uses, very often there's a comp plan amendment and a rezoning that comes together. The few that I've done here, sometimes I describe them to you together because they are both relevant to the change in zoning and the change in land use, but then you go on them separately. And they actually have different standards in terms of how those decisions are made. But each of your decisions needs to contribute to the larger vision and the orderly development of the city. Land development code compliance. So we've talked about comprehensive plan consistency, land development code compliance. So all land use and zoning decisions have to comply with the land development code as well. Each type of decision has various criteria in the land development code. When you've seen the staff reports come forward, we've gone through those criteria for you. And when you guys make decisions, you're supposed to make decisions on the basis of those the criteria that are set forth in the land development code. Depending on the type of decision, some decisions are quasi-judicial, and you're taking input from the public, and that input is very important. If you are making a site plan decision, and we'll talk about this a little bit more, those decisions are almost totally criteria based. So those are more or less, you're holding a public meeting so people are informed about it. They will give you their input about it, but you meet the setback or you don't. The other thing that's important, and you have to, again, this is something that's always very difficult to interpret, but that's what your role is, and you guys have to do this together. Each of your individual, all of us might have a different idea of what the public interest is, but you guys have to come together in your decision making and determine what that is. The ultimate goal is to promote the community's health, safety, and general welfare. And you often see that language in whereas clauses, in ordinances, in your basic you're looking at the broader impact of your decisions. You're looking at things like, neighborhood character, impact on services. Is this something that's sustainable? Is it affordable? Will it, impact environmental quality and traffic as well? And, and almost every decision, somebody wants to talk about traffic. Due process and fair hearing. So transparency and fairness are fundamental. So you need to ensure public notice, public participation. You have to base your decisions on the evidence and facts that are presented before you at public hearing. Due process is something that is owed. It's owed to people who are directly impacted by a project, and it's owed to the applicant. So, there are, many times in a public hearing, you will hear people who live in the community and they have an interest in it, but they may not be somebody who's directly impacted by a project, right? But very often, surrounding neighbors are provided notice. So there's a duty to give those people due process, and then often, and the applicant as well. All right, so they have to have an opportunity to be heard. One of the important things that you do as part of your hearing process, and we've already talked about this, so we've talked about things like being consistent with the comp plan, the land development code, and meeting the criteria. When you guys make decisions, it's very important that you clearly articulate those decisions. If there are criteria in the land development code, when you make a decision, you need to make it clear that you're making your decision based on that criteria. You're not making the decision, we didn't just, ask people to raise their hands in the audience and count it up and make a decision that way. We're looking at that criteria, and that needs to be explained, prior to making a decision. And it's particularly important if this is an item that's controversial. If you think that this is something where there's going to be, well, it can happen either way. I mean, decisions are often challenged either if you approve something or you deny something. Most often, though, they're with a denial, and those challenges come from an applicant. And very often, when they are challenging something, they will explain that the decision makers, either the planning board or ultimately the city commission, didn't explain. They denied us. They never really explained why. We heard that there were a lot of people in the audience that talked for several hours and said they were against it. But the planning commission, just made a motion and voted no. And so that can be one of the ways that a decision is attacked. So you don't all need to, not every planning commissioner needs to, go through the criteria or give a rationale. But at least one person who's making a decision, who's part of that decision-making process, needs to at least articulate that. So let's talk about different type of decision making, and each type has sort of different standards and procedures and implications. And so the three primary, you've heard me talk about them a little bit: legislative, quasi-judicial, and administrative decision making. And the planning commission, you do essentially all three. Legislative, you do largely as in an advisory role. And so, as the slide explains, we normally use that word legislative, when you're making laws. So that has to deal with creating laws and policies and, broad, sometimes very broad decision making. So the standard of review when you're making a legislative decision is it just has to be reasonable. There's like a reasonable man standard when these things get reviewed, meaning a piece of legislation that the city decides to adopt could be in regards to anything. It could be in regards to how we're going to treat the parking of RVs on property. And so, all sorts of people in the public, RV owners, neighbors, all have different thoughts and ideas about how those things might or should be regulated. And in terms of somebody challenging that, whatever ultimately the Planning Commission, the City Commission come up with, if it's reasonable, if it's a rational decision, it's going to be hard for it to be challenged. So that is sort of the lowest, the easiest bar in terms of your decision-making process. So one of the things that is interesting, I said oftentimes land use decisions involve both a comprehensive plan change, so a map change, and a zoning change. And both of them are coming forward at the same time. There's a declaration in state law that comp plan decisions, so the map changes, are legislative in nature, but the zoning changes are quasi-judicial. So, while zoning hearings can be very intense, involve a lot of presentation of evidence, and sometimes, and they're usually all done together, but the decision-making standard associated with a comp plan change, as I said, is legislative. So there's a lower bar for that decision, even though it's the same property and it's essentially the same thing. So if you think something's controversial is going to be denied, once you vote against the comp, once you vote it down on a map change, it's much easier to vote it down on the rezoning aspect because it wouldn't be consistent with the comp plan. So some strategy there where you talk about that a little bit further, particularly, when it becomes relevant, and it's just kind of a peculiarity of how Florida law works. In most states, those would both be legislative decisions. So quasi-judicial. Quasi-judicial, you're acting like a judge, quasi, because this is formal. This is a planning commission. We're not in a court of law. We don't have formal rules of evidence, so that's what makes it quasi. But you're still looking at you're looking at a request, and you're comparing it to existing standards. Some of those standards might be very general. They might be asking you to make decisions about its impact on the character of a neighborhood, but you're still applying those standards to that particular property. So in Florida, they cover rezonings very specifically by variance. And so when you're doing something that is quasi-judicial, this is where it gets very important to talk about things like, giving your rationale, explaining your findings clearly. This is when you've got to make sure that, notice is given to affected parties, and that you're basing your decisions, solely on the evidence that's before you. Like I said, I'm not going to read, these wall of text to you, but the decision makers must apply existing standards, criteria to the facts. So I'm reading that last sentence, the case, and base their decisions on competent, substantial evidence presented during the hearing. So that phrase, competent, substantial evidence, comes out of the body of law and the court cases that have developed around people challenging is that. So, so competent, includes expert testimony, any studies that have been presented, things like property appraisals, and people can bring in property appraisals and say, we've consulted a property appraiser and, this is their opinion in terms of, whether it will affect property values, as opposed to, and you got to weigh that, because neighbors very often will come in and say, oh, this is going to affect my property values. And then you'll have a property appraiser that's brought in by the applicant who's, goes through their analysis. So you got to, weigh those sort of things and decide, which evidence is most competent. And then substantial just refers to the amount of the evidence. So that's the standard in qualified decision making. You got to base it on competent, substantial evidence.
We had a case in Maitland right as I arrived there, so I wasn't involved in the central business district. A big apartment complex wanted to come in, 300 units, all residential, which wasn't permitted, so they were seeking probably a variance, or and the staff found it compatible with surrounding uses and was recommending approval. And of course, the applicant had their experts, and the commission wanted to deny it, and they couldn't, and they were very frustrated by that, because they had no competence, they had no experts that would stand up for the public. The public would have to hire someone to say, this is inconsistent with the surrounding uses, doesn't meet the criteria. They didn't have anybody, and so the commissioners were very frustrated because they had to vote yes when they, majority of them wanted to vote it down. So that competent substantial is very important.
Yeah.
And this is also where they have to divulge any ex parte communication.
Yeah, we're going to talk about that. So, yeah, so that's very important. And there's sort of a filtering effect. When stuff gets to you guys, staff is normally recommending approval, because the people who we tell we're going to recommend denial on this, you've not met the criteria, do one of two things. They withdraw their application, or they've revised it, sometimes multiple times, till we say, okay, this, you've met the criteria. So there's this sort of filtering effect. So sometimes, when things do turn out to be controversial, it can be very difficult for the members of the public to, bring forward and present substantial, competent evidence. But it does happen, I mean, I've certainly seen situations where planning boards or city commissions have, tabled stuff to the next meeting because it turns out to be very controversial and late. And by the next meeting, which is a month later, it turns out the neighborhood has, hired a traffic engineer to review something or something like that. So it does happen, particularly, but, it only happens when people are willing to, where it's so significant that people are willing to contribute. So ex parte communication. So as you heard Charles mention it, you got to base it on substantial competent evidence presented at the hearing. So what that means is, and this is a Latin word for ex parte communication, which basically just means that you've been provided some information outside of the decision-making venue, in this case, your meetings, or outside of the public hearing process. And so that will get the city, and sometimes people as individual members in trouble. So you always have to, first of all, if you can avoid it, avoid it. If a neighbor, somebody calls up knowing that you're on the planning commission and says, hey, I'd like to talk to you about this. This may be somebody you've been friendly, you just have to explain to them that that you really shouldn't be talking about this, and you don't want to talk to them about it, and come to the hearing and you'll get your opportunity. That's what we're here for. Public input, public engagement is what we're all about at the Planning Commission, so come to the meeting. But it's not against the law for you to talk to them. If you do talk to them, though, the law requires you to say that at the meeting. So, and you know, if you're a city commissioner, and if you're elected official, particularly, they don't like to tell people, "Oh, I can't talk to you. I know you voted for me, and you know, I've known you for years." So very often, at the planning commission is often, I mean, city commissions are often disclosing that, oh yeah, several of the neighbors called me. Sometimes, you know, sometimes applicants will contact you as well. And here's the other thing you have to be careful of. You can't say you're going to speak to the neighbors, but then when the applicant wants to speak, you know, once you've said you're going to speak to people, well, then if the applicant contacts you, because you're supposed to disclose it, and then if the applicant hears, oh, well, you know, I called and said I wanted to have a meeting with you, and you told me no, but you met, you know, with the guy who lives 3 houses down with you. So just be careful.
Isn't the best way to do that would be just to say, come talk to Charlotte at City Hall?
Yeah, I mean, the best way to do that is to
avoid that.
To avoid it.
Yeah.
But legally you don't have to, but you do have to disclose it, because the applicant or the opponents need to know, well, you as planning commissioners are, you know, have received input outside of the meeting. But again, you know, if you're doing things right, if you're following the criteria, if you're clearly articulating, you know, what you know, here's what we heard during this hearing, you know, if you're laying out your findings and giving your rationale, and it's based on stuff that happened in the meeting, that, you know, to some extent inoculates you from that argument. That, you know, if people know that neighbors have talked to you, or the applicants talked to you, but, you know, then you just said, okay, you know, I'd like to hear a motion. Motion's no, let's vote for it. And you haven't really put your rationale on the record, then they start wondering if it wasn't that ex parte communication that made the decision. So just, you know, transparency, you know, fairness and transparency. Administrative decision making. So some of the, you know, Charles makes a lot of administrative decisions. As your planner, I make a lot of administrative decisions, but you all make administrative decisions as well. And we've talked about this. So, and sometimes this can be difficult, particularly if you've been on the planning board a long time and you've been making a lot of decisions, and you've been doing a lot of zoning stuff, and then, you know, on occasion you'll get a site plan. And so those site plans, again, as I said, you know, they're reviewed, they've gone through this sort of wash and rinse cycle, you know, with your staff. And, you know, if we're putting something on the agenda, we believe it's met the code, or sometimes there are certain, you know, conditions that get imposed that don't necessarily relate to code issues, yes or no, but might relate to, you know, some utility issue or something that's not strictly spelled out in the code, but it is an important matter, so there's condition associated with it. But if something's in front of you and it's an administrative item, staff is pretty much assuring you that they believe it meets the requirements of the code. And so these are public meetings, and very often you do hear, you know, you hear from the public, and, you know, they may be opposed to it. And so this is sometimes where, you know, this should be the simplest and clearest decision-making process, but cities do get themselves in trouble when they've denied something because a large number of people showed up when it meets all the requirements of the code. And that happens all the time. Usually your planner and your staff will get you out. I've actually been hearing it now. This wasn't a denial, but it was, stuck out in my brain. This wasn't that long ago. I was in a hearing in New Smyrna Beach, and it was for a plat. It wasn't my item. It was one of the items ahead of time. Because not only do I represent you guys in other cities, I also represent clients to cities other than the cities that I work for. So there was a subdivision ahead of us, and this was a final plat. So there was a preliminary plat. They constructed all the improvements, and all they need to do is get the final plat document. So the final plat document is basically a really complicated survey with a lot of dedications on it and a lot of legalese language. So at this point, all the development was really done. They need to get the final plat approved in order to finish the subdivision process and sell lots. And a couple of the planning commission members, for some reason, because they had been talking about apparently these issues at another meeting, wanted them to condition the approval of the plat on the developer putting solar panels on all the houses in the development. And the lawyer had explained there's nothing in the code. You don't have any basis. You could ask the applicant if they'll do that, but there's just absolutely no basis for you to create something. It is, you're making the decision just on the criteria. And that passed 3-2 with those people voting no, because they then asked the applicant who put solar, and he had a very reasonable explanation. He was a developer. He was selling these to home builders. He's not even the one building the houses. He was just putting in all the infrastructure, selling off the lots to home builders. But 2 planning commissioners voted no. And I know that the attorney, was very stressed because it was 2 no votes and then 3 yes votes. So, when you're making administrative decisions, it's the land development code criteria, period, basically. Okay, Florida Sunshine Law. This is something that I'm sure you've all heard something about it. And there is more to this law than I'm going to talk about tonight, but it is very important in Florida. And it is one of the reasons why, interesting, we all have heard about this thing on the internet, Florida Man, right? Why is there a Florida Man? Because there's a sunshine law. So all the records that the government possesses are available to sunshine. So you can get a lot of information about people being arrested and people doing dumb things that are not, in a lot of states, government's records are not protected by sunshine laws. And so, if people are doing dumb thing in some of those states, it never gets in the news. There's no, that's why Florida Man has become a meme, because, and this is something that's a big part of Karen's job. She's the custodian of the records. And so, all the documentation that's presented to you guys is a public record. If somebody brings an item at a hearing and talks about it and it's not actually been provided to you ahead of time, Karen gets a copy because it's a public record. So that's an important component. So 3 components: open meetings, public record keeping, and ensured transparency. So 3 allegations, and here's where I'm gonna start reading stuff to you, because this is, where it gets important. Reasonable notice of meetings subject to the sunshine law must be given. So that's 1. 2, the public must be allowed to attend meetings. And so we'll talk about that a little bit more, about what constitutes a meeting. And the other requirement of the law is that written meetings are required. All right, so people have to know about it. They have to be given an opportunity, and then there's got to be a record of what happened. Okay, so when is there a meeting? Well, there's this kind of meeting, right? But there's another kind, what potentially is considered a meeting by the law. It's like when 2 or members of the same decision-making body or an advisory boards discuss a matter that may foreseeably come before them. So if you and other planning commissions are best buddies and you decide to go fishing and you then, hey, talk about some item that's on the planning commission, that is a public meeting. It is covered by the sunshine law, but you guys are in a vehicle and you're heading to go fishing. So there's been no notice of it, to the neighbors. They've had no opportunity to attend your fishing trip, and there's no record of it. So that's a violation of the sunshine law, right? Because that's by law deemed a meeting. If you're talking to a fellow board member about an item that is before you or could conceivably come before you. So if you're on that fishing trip, you need to talk about fishing and, all the good things you have in common besides your interest in the city and, your items on the agenda.
That's the issue we're having with the design committee, with Main Street. A couple of you serve on that committee, and then things like wayfinding and electric charging stations are likely to come before P&Z. So it's what we talk about, maybe publicly noticing those meetings just to avoid the conflict with the sunshine law.
Correct.
I thought that was being done.
I don't think have we started that yet? Noticing
I don't know
meetings?
when their meetings are. I'm supposed to get together with Michael Frank, who is the chairperson of that committee, I guess. Is that not right?
Yes. Yeah.
He is? Okay, so he's supposed to let me know when the meetings are, because otherwise I can't advertise them if I don't know.
Well, I brought this up 5 months ago,
Mhm.
and I purposely didn't attend them until the last one recently, where I was sure that it was advertised.
I don't think it was.
I didn't advertise it, not unless somebody else did.
Well, and there wasn't a conflict because Brad wasn't there.
Okay then. We're good, we're good. But if you want to, let me know, of course, you guys are at the meeting, so it doesn't matter, you can email me the dates of the meetings are timed, because.
Right. Now, if there are 2 planning board, if there's somebody who's if one of you is on a subcommittee and it's a public meeting and one of you shows up, you can sit there, you're a citizen, you could listen to it.
No, we're talking, they're both on the
This
same
isn't that
board.
Okay.
situation.
Oh, okay.
They're both
So you're
on the
both
same
on the
board.
same board?
Yeah.
The committee.
So yeah, those should be, what you guys notice. It's covered by the sunshine law, should be covered. Should be noticed, should be minutes.
The last one was Monday, March 11th.
Okay, so do you know when the next one is?
I think it's the second Monday of each month.
The second Monday of each month, okay.
So let's continue on with, so we've told you that, obviously there's these kind of meetings, there would be anytime 2 of you are together and you're discussing it as a meeting. If you guys create a subcommittee, if you ask, members of the public to form a formal committee to advise you on something. For example, we talked about RVs. Let's say you have RV legislation in front of you and it turns out to be really controversial. You can't make decisions. You say, hey, let's get a group of, people who live next to RVs and some RV owners and have them hash something out and bring it to us. That's covered by the sunshine law as well. We've delegated some of your In that case, you're delegating some of your advisory role to the city commission, to this group of citizens. So if you are covered by the Sunshine Law and you delegate, any of your responsibility to anybody else, they're covered as well. Okay. And I've talked about this. So, I talked about the fishing trip, but you can't engage in private discussions with each other about boardmen, either in person or by telephone, by email, text, or any other form of communication. There's actually court cases out there now about people communicating through Facebook and stuff like that.
That includes commenting on a string. You may not really even realize 157 comments up, someone else had commented already, and that can be construed as a meeting.
Yeah. Yeah, sometimes it's very challenging not to try to straighten people out on Facebook when you actually know the facts. But it can be very dangerous, But believe me, I certainly understand the temptation,
Well, another issue we have, we've kind of remedied it by BCCing all of you, but we've had commissioners reply all inadvertently when we send something out to the commission. So we've taken care of that as well.
Right.
And so you guys should never have to worry about replying, because even if you reply all to them, they're going to me, because I have it all PCC'd everybody. It'll go to me and Charles actually, if you say reply.
And then the last line here is board members may not communicate through a liaison either. So you can't, have your friend, transfer information. You can't have staff transfer information. Sometimes that can be very difficult for city managers because they're often talking to multiple commissioners about how they're voting on stuff. And, sometimes commissioners who are thinking about things often want to get a feel for how things are going to, be received. And, that can be a difficult thing for city manager. Here's something I brought up because there's been cases on that. People can come in and sometimes this has gotten people very upset. Some people put their own tape recording devices right on your counter. They want their own record. You don't know what they're going to do with it. Or people have brought in their own videotaping. That's allowed, as long as they're not doing something particularly intrusive. It's an open meeting. And, if they want to, set up a video camera and zoom in on one member, they can do that. As long as they're not, really being disruptive. But that's, particularly, I guess, there's a court case, somebody had an issue with one member and, started videotaping, just them and then, putting that up on the internet. And turns out you're allowed to do that. Yeah. And this I'm going to go over carefully. Voting conflicts of interest. You heard me talk earlier about being, ethical, and so obviously you can't vote when you have a conflict of interest. But Florida law is very specific about what a conflict of interest is, and if you don't have a conflict of interest, you actually have an obligation to vote, right? Sometimes you'll have planning commissioners who say, I just prefer not to vote on this issue. It's in my neighborhood, and I don't want my neighbors upset with me. Well, if you're at that meeting and you don't have a conflict, which we'll talk about, then you're obligated to vote. So So planning commissioners may not vote on any matter that would result in a special private gain or loss to themselves, their business, an employer, or relative. So what is that special private gain? Okay, so say if there's a project in your neighborhood and there's a lot of discussion that it's going to affect the property values of everybody in your neighborhood, yours included. Well, that is not a special private gain. That's a gain or loss to a whole group of people, one of which you might belong to, but that's not a special private gain to you, and that would not be considered a conflict of interest. A conflict of interest would be, you specifically are going to be the only one in your neighborhood that will either gain or lose from this. That would be a conflict, and you shouldn't vote on it. You must announce the nature of the conflict before the vote, abstain from voting, and file a memorandum of voting conflict. So if you're at a meeting and you're not going to vote, you have to explain that, right? The applicant, that's part of the due process, either, if you're in opposition or vote, for example, so if somebody's abstaining, so instead of, 3 of 5 votes, I got to get 3 of 4. So that might be harder, so people need to know that. And you may not participate in discussion without first disclosing the nature of the interest in the matter. So you got to do that early. Now, there are some conflicts where it's you're not sure. You don't necessarily have to. Really depends upon how you're attorney. For example.
A good example, Mark, would be when the commissioners were all going through that recall and they were trying to get their reimbursement of their attorney fees. Each one of them had to step off and say, I filed a Form 8B with the clerk and I will not be voting. And then they can, right away, they can discuss whatever's going on in their case, and then they just can't vote.
Yeah.
So that's like a good example.
So
it was from them,
Yeah, I'll give you another example, and this is just sort of like an edge case. It's just sort of an abundance of caution. So I have a employee who happens also to be the chairman of the planning commission in New Smyrna Beach. So he obviously can't, if any of our items go to New Smyrna, he can't vote on it. And so automatically we're down one potential vote there already. But there was an item that was brought forward to place a moratorium on a very large development, of which we developed a portion of it. So they were going to put a moratorium on development in New Smyrna based on this project, and it would affect this project, and we designed a portion of it. So the attorney in that particular case said, well, is it going to affect your client? Is your client going to lose any? I mean, is your company, your employer going to lose any money? The answer was no, because it's already designed. It's been largely built. All the infrastructure went in. There's just pieces and part where buildings would go in. We have nothing to do with that. So in that particular case, their attorney said, well, fill out a form in case this gets challenged later, but you don't necessarily have to declare that publicly. But again, because there was that absence of that special private gain, that form was filled out basically thinking, well, somebody connects the dots between you and your employer. They may challenge it later. There'll at least be a form in the record. So, if you do have a conflict, it's better to, over disclose than not. And that's really it. I'll be happy to answer any questions you may have.
I have two areas that I'd like to get some clarification on.
Can you speak into your microphone?
I have two areas I'd like to get some clarification on. One is the glamping park that's going on at the end of Prospect Street. You know, that's been in the works, so to speak, for close to 3 years, but they haven't broken ground. The minutes from the last commissioners meeting stated that they were going through water zoning problems, and
The St. John's Water Management District.
yeah,
Yeah.
so something, you know. I would like to see something spelled out a little bit more. I mean, what kind of problems are they going through? If we're supposed to oversee what's happening, we should know. I mean, what are the ones?
Yeah, I don't know specifically what wording, and what I do know they're going through is they're going through state permitting in regards to, there are some wetland impacts along the lake shore.
Right,
And so all those processes take a long time, and they obviously can't, they can't do any work until they have those permits in hand as well, because they have their own entirely different set of criteria, and they have their own jurisdiction. So while you guys can approve, authorize certain types of work, and you guys are looking at kind of the whole project, St. John's is looking at their rules and making their decisions based on that. And sometimes those things can be lengthy and complex, but you're looking at the city's landed on the code and the city's
right.
criteria.
Well, the other thing,
Part of the challenge there is, so when they submit their plans to St. John's has like 30 days to review, and then they come back with some comments. So then the engineering firm has to make those changes on the drawing. They've got, they already have a queue of work they're working on. They gotta work it back in the schedule, make the changes, and they have a certain number of days to resubmit. And then St. John's has another 30 days to respond, and so it just drags it out.
okay, well, my question is, shouldn't that have been done up front before, when they were submitting their plan? Shouldn't that information have been part of their plan?
Well, you had to approve the plan first. The commission had to approve it, so they knew this is the approved plan. Now they gotta go get it permitted.
Yeah.
Okay, well, then the other thing is, how long can a project like that drag out? Because things change over time.
Yeah, so there's,
Can you go 10 years without breaking ground?
that happens to be a PD. I don't have the PD memorized, but there's probably some language in the PD that talks about, how long they have
Well,
to.
you wouldn't really know, I mean, say probably doesn't.
We'd have to look at it. I'm saying I don't have it memorized. Okay. That was a PD that was adopted just prior to my involvement.
Excuse me, PD, what's that?
Plan development.
Plan development. So, like I said, there usually are criteria in that, but usually a site plan is good for a specified period of time. And so,
I mean, at any point, since the city approved that, right? First, the city approved that.
Yes.
yes,
So at any time, do we hey, look, we need to relook at this?
not if it's still valid, that'll get you sued.
Okay.
Yeah, because if, it's like, when you have something and it's approved, but when you start working, like you said, then you gotta take it to the, St. John Management, they gotta do, so you gotta try to correct those things. Then you may be doing something else, and you find here's another problem here, and it just keeps
So
going.
this could be a never-ending project.
So it's an active project.
Yeah, it's active,
And you get
so
the
it's,
permits.
yeah.
No, it happened. I have a site in Ponce Inlet. It has it's a marina development. It's a site that has a tremendous number of historic trees, and it also has it's got a midden mound from, an Indian midden mound on this piece of property that has all sorts of rules and regulations. It's been 4 years.
Well, my other question is, will they start submitting, questions, can we have a variance on this? Can we move forward if we do this? I mean, are we gonna start adjusting the development plan so that they can come to fruition? Or is that development plan solid?
Well, they have two things. They have, there's a overall development plan in their PD, that's more a conceptual plan. Now they have a site plan. And those are supposed to be the engineering instructions on how to build that site. That's what's being approved when you approve site plan. So those are pretty solid now. They can amend them, they could come back. First of all, they could tell us that there were some, St. John's, their impacts are, although it's taking a long time, their impacts are really not that extensive. It's wetland impacts at the shoreline. Sometimes I've seen projects that, have fairly extensive wetland impacts. They get approved at the sea level, they go to St. John's. Oh, we're now, we got to redesign the site. And they do have to come back through the process because, whole features of the site plan got moved. So
that remains to be seen.
Yeah.
So that's small stuff. Okay, my other issue is, after we've gone through the comprehensive nature of all this, there are a lot of building permits that are being issued here in the city, which we don't know anything about. We never get privy to what building permits are issued. So things are happening in the city regarding housing remodeling, housing development, that we have since we don't have privy information to those permits, we don't know anything about what's going on there. So it's kind of like, it's lost. I'll give you an example. The house next to me, 515, I guess, South Prospect Street. And the house is 102 years old. It's old, okay? And the bugs have had a field day over there. They started working on the roof to replace the roof on it because evidently it was sold at auction, and then somebody who bought it at auction ended up selling it to somebody who thinks they're gonna remodel the whole thing. Okay? I think they have delusions of grandeur there. And so first of all, when they started putting the roof on, they had our zoning department put a stop work on it because they never got a permit. Okay, then they went out and got the permit to redo the roof. But that was issued through the county, nothing to do with us, we don't know anything about it. And the problem is that a house that's 102 years old probably has some foundation issues, and there's a question about the septic tank that's on the property or not on the property. And it seems like the cart was put before the horse. When I called the county in reference to the permit, they said that the homeowner has the right to protect his property, and he can put a roof on it, even if the bulbs of the property are completely rotten, they can still put a roof on it. I would think that we should know whether or not that property got an engineering approval first. I mean, why put a roof on something that's not gonna get an engineering?
You see, that's something that, this is where you will get yourself in trouble. Right? You have to stick to your purview, right? That, you might have all sorts of opinion and maybe a little knowledge and expertise if you've done, building in your past, but those, re-roofs, people changing windows, that's covered by the building code.
Right. So my question is there some way that we can get notified of county permits that are being issued so that at least we know what's going on?
So that you could do what? I mean, I'm asking this question for a reason. So you could do what? You can't object to the re-roof. You can't write a letter to the county building official and tell them.
Planning and zoning has no control over what people do or build or anything.
There are certain decisions that the land development code says come to you, And those are the decisions that you can make. You as a group can't decide, hey, I saw a re-roof. I'd like to have that re-roof come before us at the next meeting, explain to us, what they're doing, structure there's no language in your land development code that gives you the authority to do that. So you can't do it.
But that goes back to becoming familiar with all of those.
And the list of the permits issued is in my report every month to the commission. The building officials over everything you described.
Yeah.
We contract,
Right.
many cities have their own, we contract with the county to be our building official.
Right.
And they provide me with a summary report, it'll say like, there were 6 residential permits this month, 3 of them were roofs, 1 was mechanical, 1 was AC, and 1 was a pool, whatever it was. And all the pie charts and so forth.
Oh, okay, so at least somebody in the city is getting.
Oh, yeah, I mean,
Yeah, but,
Yeah,
I don't know, if you read the,
right.
Charles
But-
monthly
Right.
report, it's all there.
But it's strictly just for your knowledge, there's not,
Right.
I mean,
But
I think if you guys are the land and the layout and all that, then once they're building stuff, that's the building official.
yeah.
Right.
And because I know back in 2008, there was the person that was the chairman, they got into, they wanted to have a law to tell you how many people can stay in your home. And I was like, no, that's not what we do. That's, and they want it, because that's not the scope of what we do. And, if you got 10 people in your home,
well,
Yes.
there are cities that do regulate family size, that sort of stuff. So it is something that at least would be up for discussion, but again, that is what I'm, when I talk about things, determining what's in the public interest it's not what you think is the public interest, it's what you all think is in the public interest collectively and can agree to. And, that's something, that, really needs to be talked about because, you're talking about, who gets to live where.
I have a question, and it's sort of off base, but Brad's comments brought it up. So, like I said, there's the Zope house, which we're familiar with, and it's on septic problem. So, obviously, it's been grandfathered in, but we have city water and waste. Any remodel, wouldn't they be required to hook up to our city systems?
It's probably a threshold, right?
Well, it's on a septic tank, is the water and, or wastewater, is it immediately adjacent to the property?
No, it would be down the street, it runs on Prospect,
Yeah.
I believe, and they're about,
Well, it's not going down to the other houses down the street?
I'd have to ask Keith, I'm not really sure,
Well-
yeah,
Are you talking about the,
little Prospect extension.
yeah, I know, but I used to live right across from there, I used to live on that extension on the water. So you're asking if the sewer lines go down there, is that what you?
There is no sewer down there, the sewer
Right.
ends at Jason, our fire chiefs.
If it's immediately, if it's one single family home and it's immediately adjacent, the water line's right in front of it, you can give them a year's, you can put them officially on notice that's available, because they could argue, even if they've lived here for years and years, they could say, well, I had no idea. Love my septic
So
tank.
that's both with,
So they can be given a year, they have to be given a year's notice, are required to connect. Now, if it's not adjacent to it, well, then it gets into,
sure, I can understand
Yeah.
that, but if it's running from the property, then that's adjacent.
right,
And I assume that they would have to, there isn't an option. I wouldn't think there's an option just to hook up for water without sewer, if both are available there.
If both are available, yeah, I don't know where the sewer line is there, because I know in, a little further north, there's like a loop that was put in privately, there's a private lift station in there. We go in there and maintain it, but the owners, there's a big lot that got subdivided. And then there's this lift station, sewer line, but I don't think it goes that, I have to check with Keith.
Oh, I see. But normally that's the case.
I think
It's
our
a federal
friendly doesn't
property.
require you to hook up, yeah.
You've got to hook up. Okay,
Because that house was sat empty for so many years and was in such bad shape, this may be an ignorant question, but when they go to get a permit to remodel and do whatever they're going to does someone check the septic to see if it's actually operational or if it's being bypassed?
Well, I talked to the people that live next door. There's a main house down there, and then that small house goes to servant quarters. Okay, and she's under the opinion that that house, the small house, is connected to their septic tank. No
Wow.
one's done any discovery on that yet, but I'm sure to get a building permit like I did, you have to go to the health department.
I mean, somebody should check that. I mean,
Well, that's why I was
I'm
wondering.
sure they get their CO when it's all done, they'll be inspected. Building official, building department will.
Well, it'll have to be inspected before they can get their permit. The health department has to go out there and give you a permit to put a septic tank in. The other problem is, I don't know if there's any room around that house to put a septic tank in, or a field, the field tank is small, but you have to put a field in. And I was just wondering, I know the property was auctioned off and then sold. Did anybody put any information in the disclosure regarding septic and,
It was sold at auction.
yeah, it was sold at auction.
I guarantee you it was sold as is. Do your own due diligence. Yeah, banks disclose,
Are there any other questions? We have one item, remember back when we were looking at the master plan? Well, our code requires, P&Z to review the redevelopment plan update and determine that it's consistent with the comprehensive plan. So, and our intention was to bring it to the commission on the 11th. First of all, I need to see if you guys are able to meet on the 4th. It's the first Thursday of the month. I will provide you with those documents next week when I get the final draft. And then I'd like Mark to talk a little bit about how you do that. Like, how do I know if it's consistent with the comprehensive plan? The comprehensive plan is a giant document. But that'll be your task to find a consistent and recommend to the commission, for approval that it's consistent with the comprehensive plan. So, first of all, can you all meet on I think it's the 4th? First Thursday of the month?
When the answer card is not full.
I think so, but it's complicated because of the captive fish festival.
Okay, we should,
Not preparation.
2 days later, yeah.
Yeah.
It's close.
We start
I apologize
setting
for
up
this.
on Wednesday or Thursday.
Yeah, you guys start
Yeah.
set up on that Thursday, but he said just the big stuff that he was gonna bring in, and then that was it.
Veronica, are you available?
More on Friday.
Yes, I should be, that's something the 5th and 6th, and it's,
So the meeting would be the same time, 6?
Yeah, that works for everybody.
Yeah, how long do you anticipate?
I don't know, maybe an hour. I hope it wouldn't go more than that. If you've all read through the master plan, what's addition to what you've already seen is the implementation strategy, a lot of text at the end. And then the redevelopment plan really mirrors that implementation, plus there's a lot of language, sort of authorizing the CRA to spend money on things. Like, if it's not listed in that plan, we can't spend money on it, whether we do it or not. We don't have to do it, but the redevelopment plan talks about everything the CRA is gonna do, and then in the master plan, there's an implementation strategy, kind of chronologically talks about when stuff will happen. So main thing is we haven't put anything in the plan, the pictures, you look at the vision that's inconsistent with the comprehensive plan. I mean, if you could talk about how they do that kind of a review.
Well, I know how I would do it as a planner, and then we and you guys kind of need to mirror that. But, I'm going to, first of all, I'm going to look, at the maps in it, see if they recommend any land use changes or, changes of use that don't match the future land use map. Now, there very often there are master plans that recognize, hey, we want to change this area. Oh, it's not you know, the future land use map the city has, you know, says it's gonna be, residential, but, you know, we want to change it to, you know,
Like the
office.
school is
Right.
institutional, and the future land use is probably institutional.
Right.
And this map shows it as a mixture of residential and mixed use and
Okay.
institutional.
So the master plan should in some way recognize, oh, heads up, gotta you know, you gotta change the plan. I wouldn't necessarily say that, just because it shows something different, it's inconsistent, that wouldn't be a read, but if people were putting together a plan, then look at the future, you know, had no idea, thought they were just totally free to, you know, I knew, you know, the guys you used wouldn't be unaware of the need to.
There's a
Yeah,
page or two on the comprehensive plan update changes.
right.
Well, it's not gonna go till 9 at night, I'm sure I can make it.
Right.
A brief meeting.
So, you know, I'd look at that, you know, if there is something in there that says, yes, these are the, you know, gotta, you know, we wanna do this, those change, that wouldn't be a reason to say it's inconsistent. The only reason, you know, I would mention that again, if there's a bunch of land use changes and there's no language in there that, you know, if you're a CRA member, and some of the CRAs are completely independent of the city, you know, and you think you're talking to a prospect who's interested in doing something on that property, you're pointing to it, and the city wants it to be, you know, office, and it's zoned residential, and you're not aware that there's this whole process you have to go through. So that would be one of the reasons. You know, you know, are there anything in there relating to, you know, infrastructure improvements that need to be made and that sort of thing? If they're, you know, sometimes that stuff would need to go into the CIE, the capital improvement element, you know, and I would want that plan to, you know, state that, you know. So I'd be looking at those things, and then I would just do sort of a general review, you know, of the policies to just see if anything jumped out. You know, you don't literally have to review it against every sort of policy in the plan, but, you know, if there are land use changes, you should, you know, look at the future land use component. You should look at elements of the capital improvements plan. Those would be the two areas that I would, you know, focus consistently, because there's all sorts of stuff in the comp plan, you know, that relate to a whole bunch of stuff, and you're not literally.
We feel confident it's consistent, but we want you to feel confident in voting that it is. So my intention is to get you that draft. I'm still waiting for the final revisions. I'll get it next week. I'll get it out to you. That'll give you another week to read through it. Great. Call me if you have questions. And then we'll convene on the 4th. And then if everyone's good, you don't have more questions, we can vote. But I'll do a little presentation about it. Maybe I'll touch on some of those things. I'll check the capital improvement element and those things. Because there's nothing, it's like, you know, we're keeping the same heights and areas. They've recommended some mixed use and higher density residential that I think is consistent with.
Right, and that would be relevant, because there are some cities that, you know, have height limits, they're in their comp plan, they're even their charter, and I've seen where CRA, well, no, we've got to go higher, we got to get the density development. And so could you say that's inconsistent? Only if they didn't recognize, oh, by the way, this policy can only, you know, we can only change the height if we do X, Y, or Z.
That's all I have.
All right, old business. Any general discussion? All right, so,
I make a motion, we adjourn.
Second.
okay, there's been motion and second that the planning and zoning commission meet March 21st, 2024 is adjourned.
Save the presentation.
Good seeing you again, Mark.
Yes.
Yes, thank you.
Thank you for the
Thank you,
presentation.
yes.
I enjoyed it, and you saved me from we have some company coming, so this weekend, so you saved me from doing a lot of cleaning.
There's one.
Let us know when you need help again.
You'll see them again. We have a couple projects coming through the pipeline, so
Yes.
you'll see Mark again soon.
Okay.
Yes. Yeah, there are projects that are working their way through what I said with the wash and rinse, so. You'll be seeing me soon, hopefully.
I think that was.
Yeah.
Drive safe.
Take care, Mark.
Yes. Okay, the Crescent City Historical Preservation Board meeting March 21st, 2024 will now come to order. First thing we have is the approval of minutes from the December 21st, 2023 meeting.
I approve the minutes for the December 21st, 2023 meeting.
I'll second.
There has been motion and second that we approve the minutes of the December 21st, 2023 Historical Preservation Board minutes. All in favor? Aye. All opposed? Public comments? Now we will move on to our business items.
Madam Chairman, I have a recommendation
Yes.
on the agenda for efficiency. Since we're all seasoned now, I recommend that on the agenda, we delete number 1, number 2, and number 4.
Okay,
Responsibilities, goals, and recommendation.
any discussion?
I'll second it. Was that a motion?
Yeah.
It needs second.
So which one?
1, 2, and 4.
1, 2, 4.
Okay, and it's been requested that we remove items 1, responsibility, 2, goals, and 3, recommendation.
No, 4.
I'm sorry, 4 recommendations from the agenda at our Historical Preservation Board meeting. So vote,
You can do all eyes on that one.
okay, all right, all in favor?
Aye.
All opposed? Okay, it has been voted that we will remove 1, 2, and 4 from the agenda. So the next item on the agenda would be number 3, City Codes, Land Development Code.
Yes, we have finished all the workshops on land development code today. We're planning to bring it to the commission. Actually, we're delaying it to May because the master plan is coming in April, and that'll be a long discussion. So May, the first reading of the ordinance to update the code will be coming to the commission.
Okay. Alrighty. Okay, good job. Number 5, new historical recommendation nominations.
That's one we deleted, right?
No.
Report.
1 recommendation,
No.
so 1, 2, and
That
4.
one needs us to become CLG first.
Mine's different.
Yours is different.
Different.
Huh?
Oh, okay, yeah, here you go, okay.
Okay,
I was gonna say, how do you got something different?
okay. Number 6, inventory of condemned properties.
I have a question on that. But, who condemns the problem? The city?
Building official,
The
the building official,
building?
building inspector,
So the county?
yes.
Okay.
We haven't added anything to that list.
Okay. And then just for my curiosity, I mean, are we talking structural, or health? You know, is it a health department thing that you may condemn?
I think it's both, isn't it?
I think the ones we have are all building related,
Yeah, I think
not
it's.
aware of any health related condemnations.
Okay, thank you. Okay. Oh, I have one other question. How many properties do we have?
I forget, I passed that out months ago.
There was 3, wasn't
Yeah, it wasn't
there?
much.
Within the city limits.
Yeah, and one of them was the house that's being redone on Prospect, so
Okay,
that one's coming off of it, yeah.
thank you.
Okay, all right. Number 7, pending.
Not sure what that refers to.
Yeah, I was about to ask that question.
No, we got no pending issues.
Okay, so that would be. Okay, number 8, Miller. So you said, no, you said Miller Middle School.
The commission voted to form a ad hoc committee to advise them on the process of making an offer. We had a workshop to come up with an offer for the school, and they decided to form a committee to be advised on that. Also, we signed an agreement, continuing services agreement with an architectural firm that specializes in historic preservation. I took him through the building yesterday and through the main buildings, and he's going to put together a proposal to do a feasibility study for them to analyze the structures, the utilities in there, the whole everyday aspect of it, to tell us what it needs, what each of the buildings, those 5 core buildings need. And he understands that we'll be using the main building as a city hall and the others for civic use, various civic uses. So right now we're waiting to get back. I'll be able to bring that to the commission on the 11th. The cost of that study, I was going to bring our waiter. He's also doing the Masonic Lodge. Going to do a study and then the plans for the redevelopment of that site.
Is there anybody on this board, on that committee that was selected?
Well, what happened was we had just 2 applicants, and one was on this board.
Okay, that's good. I mean, I just wanted to make sure there
Well,
was
the
some.
attorney said in abundance of caution, he recommended withdrawing. And then the commission decided that they're gonna have another workshop to talk about the nature of the committee, its charge, the makeup, how long it might meet. Really was nothing out there about what do I do if I'm on this committee and how long am I stuck or whatever, how long do I have to serve. So we're gonna schedule a workshop to work all that out. And then what they may say is it'll have a planning and zoning member automatically on the board. Maybe even a commission member, or somebody wanted to have a commission member on there and so forth. So they're gonna figure all that out, the composition of that.
And they could be titled ex officios.
Yeah, which a lot of people mistakenly think that means a non-voting member of the board, but it's just means by virtue of them serving on planning and zoning, they'd be on that commission. Because we were requesting people with backgrounds in, architecture, engineering, land development, construction, design, those kind of things, so.
Charles, any update on communications with the school district on that property?
Just that I told them we don't have an offer for them, that we're gonna put together a committee and get back to them. They got made it clear they're interested in selling the property and moving on, not remaining tied up with the property. So I think that'll be an issue for us to consider. There was a lot of talk about partnership and working together on it. And so I think their interest is, I don't speak for them, but their interest is sell it. And they've got a school to build and a school to run and so forth. They're gonna have another campus to sell as well in the next 3 years. So that's another concern we have.
And was the architect enthused with the school?
Oh yeah, he loved it. He said it was best at the gymnasium. Everybody, when they walk in the gym, they go, wow. So really love school. The buildings in the back are in great shape. Media center and the cafeteria are the most recent buildings, either new or built or renovated. So they probably won't need much of anything. But the front building, he looked at it, he goes, this is a big building. He said, a building like this, it's a lot of money to restore it. So we'll see. The first step is to pay what's the cost of the feasibility study. I think it'll be substantial.
See, that downstairs,
Yeah, it's kind of rough down
yeah, and that's because they just shut it up and stopped using it, so.
Yeah.
And then, because we had classes in it when I was in school, so.
Well, this firm has done a lot. He's going to go, oh, we did a school like this in this city, and now even in the sign, like, oh, we did a project just like this over in this other community. So he's got a tremendous amount of experience.
You couldn't have picked anyone any better.
REG, you familiar?
Yeah, oh, yeah. Yeah, we hired him one.
Oh, really?
A large project with Jupiter and,
Really nice guy.
yeah, tremendous, yeah. And of course, he was president of the Florida Trust,
Or just.
Historic Trust. And was the main drive behind saving the Biltmore, when they got Clearwater, the large hotel, but they saved a portion of it, but,
Yeah, so I'm excited.
yeah, very good. And what was his thoughts on the lodge?
He said, yes, it's great. It's great that it's high up off the ground. What they do is they send if we approve the agreement, they'll send a company over that does a scan. And they scan it all the dimensions, everything in, so I think they can create a 3D model of it. He said that takes about a month to get all that done. And then I was asking about it, would we be in time for this grant cycle? He said, well, it's just thinking off the top of his head, maybe July, might have plans in hand. And I don't know when the grants, I'm thinking September for some reason, but he's thinking it was June. He might be more familiar than I am, but, so if we miss this year's grant cycle, we'll be ready for the next one, but hopefully we can at least get some applications in, this year. Once we got plans in hand, we can go, oh, we're gonna take on the porches this year. We're gonna tear all that and rebuild that and fix the roof, and that'll be this, until next year, and we'll apply for something else.
Okay. All right, number 9, our historic district.
There's no change, we have the grant waiting for final knowledge if we got the grant, the $25,000 to update the survey. We won't know, I think, until the end of June, so.
And when will that take place, that survey again?
Well, once we are approved to the funds, it's like the other, we don't actually sign a contract until fall, so maybe a few months. And once we sign a contract with the grant money, we'll do an RFP for somebody to do the service, conduct the thing.
Number 10, architectural and site guidelines.
Nothing else. Actually, they're going through the test right now because McDonald's is sending some design review. We've had some minimal comments. But I'm thinking to myself, if we don't like what we get, that informs us on our guidelines. The McDonald's is outside the historic district, so it has no requirement to meet the historical design. So it's just got to look good. And I think our standards are pretty good. They're probably pretty standard. Breaking up, no blank wall space, all that kind of thing. But I'll tell people they don't like the look. It's like, well, let's go look at the standards and revise them for the next project.
Exactly.
So it's better.
So they come back to get another permit and,
We had a pre-application,
okay,
and they've sent the drawings to make sure they're in compliance. And now we're just waiting for their full application,
okay.
which they said they will overnight us once it's ready. They're eager.
Oh, good.
Alright, sounds good. Alright, land use and zoning maps.
Nothing to report.
Alright, I think that's it. Alright, general discussion. So, if there's nothing else, we will adjourn the Historic Preservation Board meeting for March 21st. This meeting is adjourned.